I'm Sarah Pieter, solicitor and director in the childcare team at Duncan Lewis in the Leeds office, and with me is Sophie Johnson, who is a solicitor also at the Leeds office doing childcare work. We're going to talk a little bit today about when social services become involved with families because children have injuries. That can come to social care's attention a number of ways, sometimes because an injury is seen on a child by a medic or by a school teacher, or if social care are already involved, they may observe injuries to children. Obviously, children get injuries accidentally, and that doesn't lead to social care involvement. So social care sometimes become worried because an explanation doesn't fit the injury that's seen, or a child may say that they've been injured by a parent, and that could lead to social care becoming involved, at least to investigate what's happened.
As part of the investigation process, a child will be taken to a child protection medical. This is where the child is examined by a specialist paediatrician to look at any injuries that they might have. They might look at bruising, and they might take pictures of the bruising, and they'll speak to parents and provide a report to social care, setting out how they think that the injury might have occurred, and what steps need to be taken afterwards. They can also do investigations such as blood tests to see if there's an underlying reason why a child might bruise more easily, or if they've got any sort of blood disorders that might account for the bruising.
If the result of that medical indicates that either the injury is unexplained or it's suspicious, then social care might undertake a Section 47 investigation. That's an investigation, a thorough investigation in relation to the circumstances of the child. The parents will be interviewed and the children might be spoken to try and discover whether there's any serious concerns or risks that might need social care, further social care involvement, or even court proceedings.
One level of social care involvement is the Child Protection Conference. If social care are concerned about a child, then they could initiate the child protection process. You'd be invited to an initial child protection conference, and a plan would be agreed as to how to keep the child safe. It's really important that you go to that meeting, and if you've got any questions about the process or about the plan, that you reach out and get some legal advice about that. It's really important to address social care's worries to avoid their involvement escalating any further.
If the case does go to court because social care are concerned enough, it could be that they make an urgent application to the court for an emergency order. It's really important, if you're told that you get legal advice very quickly, because it's very important that you're represented in relation to those hearings right from the outset. In fact, we would say to seek legal advice at the very first stage of social care involvement. If the case does go to court, the evidence which social care have can be challenged. It's possible to ask for the court to allow you to instruct an independent medic for a second opinion, and all sorts of other disciplines which might be needed to challenge sometimes controversial medical opinion in relation to how injuries have been caused. I think the most important thing is that you must engage with social care from an early stage to show that you understand what they might be worried about, even if the injury has happened accidentally. It's important to agree for your child to be medically examined so that you can show that you want to work with professionals to demonstrate that there's no cause for concern, and seek legal advice as soon as possible so that you can be advised and represented right from the outset.